Back on the record. So in the 21-6099, it's possession of buprenorphine, a 2-year maximum, 0 to 6 guideline range. Any additions, corrections, or scoring challenges, Mr. Nightingale?
No scoring challenges, Judge. Mr. Freeman has advised me that as to CFJ 284, page 1, the very last paragraph in which it indicates that this defendant failed to cooperate with the initial pre-sentence investigation and later failed to prepare in court for sentencing. The first part of that sentence, he does dispute that he failed to cooperate. He does say that he was unaware that he needed to do a pre-sentence report, and so that would be the only qualm I believe he has with that document.
Well, I just don't believe that, Mr. Freeman, because we tell you that when you enter a plea. So we'll leave that as it is. All right, and in file 26-7139FH, it's on an absconding. 4-year statutory maximum, guidelines at 0 to 17 months. Any additions, corrections, or scoring challenges in that file?
No, Your Honor.
Ms. Goodrich, any additions, corrections, or scoring challenges from the people in either file?
No, Your Honor. Thank you.
All right, and I guess we've got a pending contempt for the failing to appear. He's sitting on enough. He's been in 93 days. He's being sentenced for an absconding. Absent objection, Mr. Nightingale, I'll go ahead and enter a contempt judgment in the 6099 file with a sanction of 93 days jail, credit 93 days served.
No.
Okay. Anything you want to say on behalf of Mr. Freeman for the sentence on both these files?
Yes. Thank you, Judge. So Mr. Freeman comes before the court, 24 years of age. He does have some other holds going on right now. He's, trying diligently, it sounds like, to get set for trial on those cases and having some difficulty in resolving them. I'm sure that the court does recall that Mr. Freeman did request an emergency furlough at some point as part of these cases to see his grandmother in the hospital. The court did, of course, deny that furlough, and he has remained in custody since he was picked up on these warrants. Judge, since he's been in, he's bounced around quite a bit, right? He's gone from Traverse to Benzie to here to back to Benzie to Traverse to this has been a real process for him to get through mentally. Right now, I believe that he's in SEG, not from anything that he did, but for his own protection out of Grand Traverse. He is asking if there's any incarceration ordered in these cases, that he's able to stay here and serve them instead. He doesn't want to go back to Grand Traverse. He doesn't want to go back to SEG, which I can understand as a human being. He's been in there, I think, for 3 months. And it's certainly wearing off.
I didn't hear the second. You didn't want to go to Grand Traverse or where?
He doesn't want to go back to Grand Traverse to go back to SEG.
He's in segregation unit?
Correct, yeah. And so he's asking to serve his time here. If the court would allow him to do that, it does sound like the court's probably going to assess some additional incarceration. It's recommended to do 6 months on.
Well, why wouldn't the jail administrator here just stick him in segregation? I mean, if somebody's in segregation because of their behavior,
it's
not from his behavior, you're saying?
That is my understanding. It's not because of behavior within the jail. It's because of the allegations of the other cases, if that makes sense.
It doesn't really.
So if the court wants more information, I'm happy to approach.
No, that's fine. I just what I generally do with that when there's multiple counties is I let the jail administrators sort that out. So if it works out best for the jail administrators to let them serve it here and they want to do that, I don't have any objection to that, but I'm not going to order one way or another.
Yeah,
I'll let the jails sort that out.
No, totally understand.
And if there's some compelling reason after they sort that out, if there's some compelling reason that you think for safety or otherwise that Mr. Freeman should be in one location, I would entertain a motion.
Sounds good. I appreciate that, Judge. Yeah, that was a big concern of his this morning, so I wanted to make sure I put that on the record for him.
Okay.
Judge, as far as his prior history, until he picked up this controlled substance case, he had no history. Did have a juvenile record, it looks like, but no adult criminal history at that point. He has now got these 2 felony convictions. He is, like I said, trying to go to trial on his other cases, is my understanding. We're going to ask the court today to adopt the recommendations contained therein. He is, I don't think, probably a good candidate for probation at this point because of his other matters. And if there are convictions on those, he's certainly going to have mandatory probation as after he's done with whatever term of incarceration he has. So not asking for any probation for these matters, just asking to accept the recommendations. If the court has no objection, hopefully the jail administrator will let him serve his time here. Thank you.
Okay, thank you. Mr. Freeman, you don't have to make a statement today, but you're welcome to. Is there anything you want to tell me?
Yeah.
Okay, go ahead, Mr. Freeman.
I'd just like to say that I'm sorry for my actions and for dragging this out for so long and not getting it handled when I should have 5 years ago. That's all.
Okay. Are you next? Goodrich, any recommendations from people?
Yes, Your Honor, thank you. We're here for 2 files on February 13th of 2020. The defendant had sold 2 pills of Suboxone to a confidential informant, and then he failed to appear for sentencing on July 13th of 2021. He was eventually located in Kentucky and extradited back to Michigan to face CSC charges in both Otsego and Grand Traverse counties. He's 24 years old. He was 18 at the time of his first arrest. He has 1 felony, 0 misdemeanors. He has the 2 cases, as mentioned, pending. He's unemployed with a 9th grade education. He has not been on probation or been to prison or jail previously. As stated, the guidelines are 0 to 6 on the possession of analogs and 0 to 17 on absconding. The PSI is recommending 6 months jail with 108 days credit on the possession case with no probation. And the recommendation is for 12 months jail with 145 days credit on absconding with no probation. I'm in agreement with those recommendations, but would ask an additional request that these 2 be consecutive due to defendant not just fleeing the area, but fleeing the state, that he had to be extradited back to the area, and that he has incurred additional serious charges in Otsego County while being on bond for the first case, as well as failing to cooperate with the PSI and failing to appear for the sentencing. In researching, it looks like the Grand Traverse CSE case appears to predate the possession of analogs case with an incident date of 2016. Thank you.
Thank you, Mr. Freeman. If you please stand for the court sentence. Well, I mean, it seems in my review that the extradition was to come back to face the CSC charges, and that the offense date on those charges predates all of this stuff, right? Is that right?
The Grand Traverse predates the Otsego, does not. He was on bond for the possession of analogs at the time.
Okay. All right. And I don't know, Mr. Freeman, obviously you've got bigger problems in your life right now than these cases. But also, even setting that aside, you made this way harder than it needed to be. You were 17 years old and got caught selling 2 pills. I mean, a court's not going to be super wound up about giving you a lot of jail for that. 17 and 2 pills, right? In fact, I tried to transfer it over to the probate court once they raised the age legislation came through, but then probate court transferred it back and said actually it didn't apply retroactively to you because it took effect October 21, and so it didn't apply to you because this occurred before then. So that was a pretty simple case. But then you failed to show up at one point, so we arrested you. A month later, arraigned you, and you pled. We let you go again, and then you didn't comply with the PSI process. That's your job. They don't have to chase you down. You got to reach out to them, and we would have told you that. And then you go show up for sentencing, and you go to another state. So now you got an absconding charge. But I don't know. I mean, these are very serious charges you have in the other counties, but I don't know a thing about those allegations or whether to, I mean, I know you're presumed innocent and have the right to a trial, but you know, when we're sentencing someone and they've picked up new charges somewhere else, sometimes, you know, it's pretty clear from those charges, you know, what we ought to think about that. And this is not one of those situations for me. So taking all those things into account, I've entered the contempt sentence for 93 days, credit for 93. In file 6099 at a range of 0 to 6 months. There's reasonable grounds for incarceration in that Mr. Freeman fled the jurisdiction of the court. I'll order that there's $68 in state cost, $130 in the crime victims assessment, $350 in court costs, $60 DNA testing fee and have to comply with that, and $40 in restitution for the buy money, and order jail for 6 months at the top end of those guidelines. And I think now we're at, by my calculation, 185 days credit. Would that be about right, Ms. Goodrich?
Yes.
So I'm going to order jail 6 months, credit 6 months. So time served and fines and costs in the 6099. You've done your 6 months on that. In 7139, the absconding, it's advisory guidelines 0 to 17. There's reasonable grounds for incarceration here in that you fled the jurisdiction while you had felony cases pending in both Sheboygan and looks like there was a case pending in another county when he fled as well. Is that right? The Otsego, it looked like. Mr. Nightingale, I thought that the Otsego case was pending when he went to Kentucky as well.
I don't know if they had filed it yet.
Okay. He maybe just knew of the investigation.
I would assume that that is correct.
All right, so there, I think the fact that he fled to another state,
The PSI
Yeah.
says that the matter in Otsego was found over to circuit court on 6/3/2021. He failed to show to our sentencing on 7/13.
yes, okay, yeah, I thought so. Okay, I thought that maybe it was. So he fled from the jurisdiction when he had not only our case, but another serious felony pending. So I think that is a fairly serious absconding. $68 in state costs, $130 in crime victims assessment, $350 in court costs. And in that file, I'm going to order that he serve 6 months in jail, but give credit for 0 days served. And I will run that discretionary consecutive to file 21-6099. All right, so Mr. Freeman, what that means is you've served your time in the 6099, but there's some fines and costs you'll need to take care of. And in the absconding charge, you got 6 months to serve starting today. I'll let the jail administrators sort out where that is best to be served. If after they do that, you've got some compelling reason that we ought to intervene, your lawyer can file a motion. If you get convicted in the other matters and go to prison, you'll want to take care of these fines and costs because otherwise it'll come out of your commissary while you're in prison. If you get acquitted of all those other charges and you're free, you want to take care of these fines and costs or set up a payment plan so that you don't come back on contempt of court charges, okay? If you want to file an appeal in either case, you can do so by filing an application. If you want a lawyer, you have to ask me within 6 months. So we're going to hand you a piece of paper about your appeal rights in both cases. And ask you to initial one copy for us. The other one's for you to fill out if you want to take an appeal. Do you have any questions for me, sir?
Nothing.
Okay, good luck.